Good afternoon. My name is Iulia. I'm a law professor. I'm teaching law at the Law Faculty of the West University of Timişoara. I'm teaching European Union law and also the international protection of human rights. And I'm very honored to welcome today here at the West University Professor Iulia Motoc. I would like you to allow me a few moments to introduce Professor Motoc to you, although I'm sure that we are practically all aware of her brilliant legal and academic career and personality. Iulia Motoc is a Romanian judge, and she's also an international law expert. She's a professor of the University of Bucharest. She teaches at the Faculty of Political Sciences. She's a judge of the International Criminal Court. She's a former judge of the European Court of Human Rights, and she's also a former judge of the Romanian Constitutional Court. She chaired a number of international experts bodies. She was a vice president, for instance, of the United Nations Human Rights Committee, and she was elected a member of the Institute of International Law, Institut du Droit International. She holds a summa cum laude doctorate in international law from Paul Cézanne University, Aix-Marseille. She also is habilitated in law from Jean Monnet Department of the University of Paris Sud, and she holds a doctorate in ethics from the University of Bucharest, that is the Department of Philosophy of that university. She was a fellow in philosophy at the Institute for die Wissenschaften von Menschen in Vienna, and also to the Yale School of Law. She taught at the New York University School of Law, where she was Senior Jean Monnet Fellow. She was a special guest professor at the European Academy of Human Rights at the European Institute of Florence, and she was a researcher professor at the Sorbonne. Her research is devoted to international law and also to protection of human rights. She has published with very prestigious publishing houses, Oxford University Press, Harvard, Cambridge University Press, but also with prestigious publishing houses in Romania, and I'm mentioning Humanitas or here. I'm happy to mention them as well. And then I would like to refer to a series of conferences that my Faculty of Law, the Faculty of Law of the University of Timişoara, initiated last year. The name of the conference is Judges of Europe, Europe for Judges, and the University of Timişoara hosts within this framework former judges and present judges of the international courts, of the Court of Justice of the European Union and of the European Court of Human Rights, and this is supposed to be a space of debate that tries to assess the help and the assistance that law, international law, can provide within the crisis of our modern law and modern society. On the other hand, we have the European Society of International Law that hosts broadcasts of presentations on international law. And the reason for these broadcasts the reason is the possibility to spread such conferences and to reach a larger audience. So I'm very happy within this general framework to yield the floor to Professor Iulia Motoc. She will be speaking for approximately 40 minutes, and then she will be glad to answer to your questions. Thank you very much.
Good afternoon to everybody. Thank you very much, Iulia, for this very kind invitation to this very prestigious series of conferences. Thank you very much to Radka, my colleague and friend, for this welcoming presentation. Thank you very much, colleagues from the University of Timişoara that are present here, to Professor Valentino, a very long time friend of mine, and to the students present today. So my theme today will be from humanism to technicism and justice, rethinking European human rights framework. So very ambitious theme. In in 1443, Lorenzo Vella, a professor of law from Pavia, wrote that he preferred one page of Cicero to entire series of work by Bartolus, whose style and scholastic Latin look so barbaric in the eyes of the learned humanist. The remark was so attacked by professors and students that Vella was forced to flee from Lombardy to Naples. Maybe this is a concentration of the history of law, of a debate between technicism and humanism, of speciality and generality that we are witnessing nowadays. Humanism is capable of receiving systematically three interpretations. The first aims at the knowledge of the humanities. Thus, the efforts made in terms of accessibility of the law are causing the heirs of the digest and the corpus juris civilis to lose their references and citation for which jurists had such a great reputation. Legal humanism will have at its aim here the culture which, perfecting the natural quality of man, makes him worthy of the name. In second sense, it covers the friendship of humanity, philanthropy, in other words, and finally, in the third sense, it aims of the consideration of a man as the holder of the supreme value, placed on the top of the hierarchy of the beings, representing an end and not a means, to use the categorical, banal Kantian imperative. It is really these last senses that the present questioning of the legal humanism is aimed at. Has law definitely banished this very transcending man, or that he, an individual, is only the end of law? The concept of subsidiarity has been a central component of the European human rights framework for its inception. It refers to the ideas that state parties have the primary responsibility to secure the rights and freedoms of the Convention, and that the European Court of Human Rights has a supervisory jurisdiction. According to the conventional wisdom, the last decade has been marked by a shift towards an increased subsidiarity which goes beyond traditional role within the convention system. A less well-known feature of this development is that the turn of the European Court of Human Rights from a normative humanist outlook based on the living instrument doctrine to an increasing legal technical approach. When it refers to technicity at the expenses of humanism, the court stresses that the consensual strength of the convention as a treaty and as a law in human rights law, without giving due weight to the underlying humanist values. The methodological technical work of defining specific rights is a crucial cornerstone of the human rights project and in public international law and national constitution around the world. At the heart of the legal technique, this argumentative dimension of what Pellerman drew attention early on concerned the entire normative process from the creation of standards to their application. Concerning all administrative, legal, and judicial institutions, the empire of argumentation is clearly manifested in the way in which legal actors approach the social data or sociological analysis, or they may know. In practice, they do not intend to carry out a work of sociology of law, but rather to make a result of sociology. However, the specificity of human rights law lies in the fact that it's only is the core of humanist values which bodies are to interpret. It must not be disregarded. An institution such as the European Court of Human Rights, with its large case law, efficient case law management techniques, and active discussion with domestic courts, is especially at risk of valuing its own rigid framework of case law above the core values which underlie its mission. In this lecture, I will show that in the last decade and a half, the European Court of Human Rights has increasingly shifted in the direction of increased technicity at the expenses of evolutive adjustment of the case law, at the core of the core humanist values underlying the Convention to the pressing problems of our times. I will demonstrate the development based on the recent case law of Article 6 of the Convention wherein this particularly evident. To do so, I will first explain the theoretical foundation of human rights and humanism, and how they can and should enter the practical work of the human rights body, such as the European Court of Human Rights, where is deciding cases. I will then address a specific sequence of cases from the last decade, which concern the right to an effective legal defense under Article 6 of the Convention, namely Ibrahim and other versus UK, Simonovic versus Bulgaria, and Bears versus Belgium, known as the saga of Ibrahim. In this context, I will show how in these cases the court used increasing technicity in the test applied in its case law to lower the standards of the protection afforded by the Convention. Lastly, I will examine how the technical test must still be amenable to be infused with humanist values on the basis of the court's most recent case law of Article 10 of the Convention. I will argue that this way of normative enrichment of technical tests can also work for other areas of the Convention, such as Article 6, and thus sketch the way out of the era of the technicity. Legal humanism and human rights. To understand the court's recent jurisprudence, its turn to subsidiarity, procedure, and technicism, it is necessary to first turn briefly to the theoretical context about the foundation of the human rights project. Generally, one can distinguish between two main strains of thought, in a simplistic way, in the theoretical foundation of human rights, namely the normative, thick, value-based approach which often equates human rights with natural rights, and political approach based on the actual practice of human rights. The former approach has several substrands. In general, scholars who espouse this approach, including John Finnis, James Griffin, or Joel Freeburg, ground their theories of human rights based on the conception of natural rights present in the history of Western political philosophy, most importantly in the works of Thomas Aquinas, John Locke, or Immanuel Kant. Here is a whole discussion about this. They argue that being human entails a number of particular and unique qualities, including the cognitive ability to reflect and assess, and to develop personal agency based on these abilities. These qualities at once differentiated the humans as a group from other animals and are equally present in all human beings. As a result, all human beings have certain rights which enable them to act on these abilities and fulfill their potential as humans. Natural law scholars do not agree upon an exact catalogue of these rights, but generally accept certain conception of personal liberty, bodily autonomy, and minimum welfare to belong to them. This approach has been opposed by thinkers as John Rawls, Charles Bates, or Joseph Ratz, who had argued for a political and practice-based conception of human rights. Indeed, here another simplification. This view criticizes the naturalist conception of human rights because, as particularly Rawls argued, concepts based on specific moral conception of a humanist, those based on a liberal secular order, cannot assert a claim of legitimacy on a global level. In a similar vein, proponents of the political conception of human rights question whether the normative value of human rights can apply to all human beings across time without any recourse to societal, economic, and political context. Moreover, in relation to the practical work with human rights, they argue that the naturalistic conception does not provide sufficient content to generate a detailed, succinct list of found in today's human rights document. Therefore, the foundation of human rights should be thought in an interpretation of the actual practice of human rights in safeguarding certain function of the international community, such as non-intervention and interest of the individuals against the state. In other words, humans do not have human rights, but only enjoy these rights within the context of historical existing political communities. This view, in turn, has been criticized for not providing enough normative guidance and for neglecting the fact that human rights documents and the political and judicial practice connected to them are themselves driven by value-based conception of humanity and dignity. Moreover, as a descriptive theory, it cannot account for evolutive interpretation approaches prevalent in human rights bodies. In recent years, various scholars had attempted to break out of the dichotomy either by the synthesis or new models for which human rights can be based. For instance, Christina Lafont has argued that practice-based models of human rights can and should accommodate moral conceptions of humanism. Similarly, Stephen Watley, using method of social ontology, conceives the human rights as social institutions, which must fulfill two requirements. First, a specific must believe and practice, and second, it must conform to some basic tenets which makes it of the definition of human rights. However, for the purpose of this lecture, all the theoretical conceptions of human rights base themselves on some value of humanism, whether they find in its intrinsic nature of the human experience, human rights practice, or in the human rights as a social institution. Consequently, a human rights body such as the European Court of Human Rights is always doing more than treat interpretation where it interprets a specific case. In today's world, Human Rights Convention and National Constitution provide a legal from the human rights state. They also take part of a larger human rights project based on the value of humanism. The European Court of Human Rights has explicitly recognized this through the living instrument doctrine. Downgrading human rights in the same technicity saga, Ibrahim, Berzet, and Simeonovi. Article 6, paragraph 3 of the European Convention of Human Rights set certain minimum rights for those charged with criminal offense, including, in letter C, the right to defend himself in person or through legal assistance of his own choosing. In the first decades of its existence, the court was very to engage in the question of whether or how the right applies to pre-trial procedure. In the 1990s, the court developed the first principle in this regard, but did not hold that the denial of access to legal counsel in the first phase of procedure by itself constitutes a violation of Article 6. However, in 2008, in the famous case of Salgus versus Turkey, the court extended the right to the pre-trial and investigate phases of the criminal procedure. In application of the evolutive approach set by the living instrument doctrine, the court held that the right to legal assistance also applied to police investigation before the authority introduced formal charges, because this was required to safeguard that the criminal procedure was sufficiently practical and effective. Thus, in Salgus, the court gave further expression to the underlying values of Article 6. However, it also explicitly recognized that the convention allows narrow exceptions from this rule and frame two-level test. First, it must be demonstrated in the light of the particular circumstances of each case that there are compelling reasons to restrict this right. Second, even where compelling reason may exceptionally justify denial of access to a lawyer, such restriction, whatever the justification, must not unduly prejudice the rights of the accused under Article 6 of the Convention, the right to the fair trial. In effect, the court clearly framed two-level cumulative test, which has been at the heart of the aim of Article 6, that the practical and the effective protection of the rights of the accused. In the decades following Salgus, the court has altered the case law regarding the minimum rights of Article 6, paragraph 3 in general and the right to legal assistance under Article 6, paragraph 3c specifically. This change must be seen in the context of increasing domestic opposition to the court's case law and the rising of subsidiarity and advances on the part of the court, what one commentator had described as a buyer's remorse. Dissenting voices within the court have gazed in future and termed the development as a retrogression of the core protection offered by Article 6, paragraph 3c. 1 decade later, in Ibrahim and other, in versus UK, Simeonovi and Bulgaria versus Bulgaria, and Bös versus Belgium, the court weakened the Salgus test. Notably, this change came clothed in normative language, stressing overall fairness, but it led not only to a lowering of the specific protection offered by Article 6, right to the fair trial, but also to a more technical analysis of the state compliance with the obligation. In the resulting two-level test, the court assesses the compelling reasons for the restriction and its effect on the right of the accused in the proceedings as a whole. The new jurisprudence on Article 6 constitutes one strand of what has been termed as the procedural turn, a concept closely related to the subsidiarity, under which the court refrains from engaging substantively with the convention rights and defers to domestic courts' decision on convention rights if they are there to a certain procedural precept. While this is less apparent, and for purely procedural rights, such as Article 6, paragraph 3, the new test results in a technical exercise of the criminal procedure as a whole to the detriment of the core substantive procedural content of the right as such. In effect, such a resulting jurisprudence of Article 6 is highly casuistic and does not allow the court to fulfill the role which the subsidiarity principle assigned to, namely giving broad value-based guidance to the state parties to the convention application. It is important to note here that even though the peculiar nature of the Article 6 molds the case law in a specific way, this development or technicity does not only impact the rights to legal assistance under Article 6 of the Convention, but is reflective of a large trend. The dissent of then Judge Pano, later President of the Court, in 2017 case of Turkish versus Italy domestic violence case is very illustrative in this regard. In this case, the court found that Italy had violated Article 2, right to life, and Article 3 as well as Article 14 of the Convention, because it had not fulfilled its positive obligation to protect the applicant from grave incidents of the domestic violence committed by her husband, which led to the death of their son and severe injuries of the applicant. The applicant's husband had already assaulted the applicant twice, and in the night of the incident, the police arrested her husband twice, but let him go again. In cases regarding positive obligation under Article 2 of the Convention, the court usually applies the so-called Osman test, probing whether the authorities knew or ought to have known at the time of the existence of a real and immediate risk of the life on an identified individual or individuals from a criminal act of a third party, that they fail to take measure within the scope of their power, which judges reasonably might have been expecting to avoid the risk. So this is the definition of the Osman test for the judgment of 1998. In Turkish, the court stressed the risk of the real immediate threat must be assessed taking due account of the particular context of domestic violence. And the prior recurring episode of domestic violence must play a part in the assessment of the risk of a victim. In that context, the court also referred to the values embodied in the Council of Europe Convention of Preventing and Combating Violence Against Women and Domestic Violence, so-called Istanbul Convention, and especially its preamble. This is the effect amounts to what has been termed as the revised Osman test, which pays specific regard to the considerations of humanity of victims' gender-based discrimination and violence. As has been shown above, such an evolution of the case law toward increased protection is in the line within the living instrument doctrine and therefore not only required by the humanist values underlying the Convention, but firmly entrenched in the Convention interpretative methodology. However, in his partly dissenting opinion, Judge Pano took issue with this revised test, stating twice that the law, even human rights law, has its limits. He stressed the formal limits of the Convention as a legal instrument and explicitly applied the Osman test without taking into account wider context of domestic violence. Notably, he took the Italian authorities' slowness in investigating the initial assault of the applicant as evidence that they could not have had constructive knowledge of a real and immediate risk to the applicant's life. In this way, the test developed in Osman the objective of a humanist approach to protect victims of domestic violence, thus by stressing that the law in human rights law, in this case the judge-made legal standards inventing to respond to the problem not explicitly foreseen in the Convention itself, this opinion shows clearly the danger of a jurisprudence whose technicist legal standards have ossified and become object in themselves, without paying regards to the underlying values of human rights project and the evolutive approach to human rights which is present in the dogmatic methodology of the European human rights system. Third part, a return to humanism, progressism as the essence of the protection of human rights. However, the Convention Foundation on Humanist Values, which forced the court to clothe its technicism and procedural term in normative language, could yet make the return in the court case law. Some of the court's most recent case law areas, other than Article 6, leave some room from hope that the new test might be in the sense for normative enrichment. Thus, in the 2021 case of the Grand Chamber, Ale versus Luxembourg, the court turned to a global analysis of the previously established criteria for assessing alleged violation of the right to freedom of expression of whistleblowers, while ostensibly stayed with the subsidiarity paradigm of a procedural review of the domestic court balancing. It found that balancing to be insufficient and proceeded to carry out its own balancing exercise. There, it found that the importance in both national and European level of the public debate on the tax practices of the multinational companies outweighed the detrimental effects of the disclosure by the whistleblower. This shows the concepts which are technicist in nature, including the overall fairness test in Article 6, bear the dialectical potential to be infused with normatively thick understanding of their content. In that way, European Court of Human Rights could find its way back to humanism. Thank you very much.